Ready? Exercise number 23, legal matter, start. The facts very briefly are that on 31/2001 at about 8 p.m. a young girl of about 14 years accompanied by her parents lodged the first information report under bracket for short the FIR bracket out in police station Khazuri Khas, Delhi, in which she is stated as follows. She was a student of higher secondary school and residing with her parents at house number 131, gully number 12, Khazuri Khas, Delhi. Opposite to their house was the house of Sardar Jagir Singh. Babbu, daughter of Sardar Jagir Singh, was her friend and she used to visit the house of Sardar Jagir Singh to meet Babbu. On 28/1/2001 at about 8:30 p.m. the lights in the area went off, and as the generator at the house of Sardar Jagir Singh was on, the prosecutrix went to meet Babbu. Stop, next para. She inquired from the appellant, the son of Sardar Jagir Singh, as to whether Babbu was in the house, and the appellant told her that Babbu was inside the room. When she entered inside the room, the appellant followed her into the room, bolted the room from inside, and forcibly put her on the cot. When she raised an alarm, the appellant slapped her. He then took out her salwar and underwear and raped her. He also threatened her with death if she narrated the incident to anybody out of fear and shame. She did not narrate the incident to anybody, but in the evening of 31/2001, she narrated the incident to her mother. Stop, next para. At the trial, as many as 15 witnesses were examined on behalf of the prosecution, including the prosecutrix. After considering the evidence on record, the trial court convicted the appellant under sections 376 and 506 IPC. For the offence under section 376 IPC, the trial court imposed the minimum sentence of 7 years, rigorous imprisonment, and a fine of rupees 5,000 in default, rigorous imprisonment for 1 year, and for the offence under section 506 IPC. The trial court imposed a sentence of 2 years imprisonment and a fine of rupees 5,000, and in default a rigorous imprisonment of 6 months. The trial court further directed that the sentences were to run concurrently. Aggrieved, the appellant filed criminal appeal number 696 of 2002 in the High Court, but by the impugned judgment, the High Court has dismissed the appeal. Stop, next para. The appellant has filed on 12/2/2013 an affidavit stating all these facts. He submitted that as the appellant is the sole bread earner of the family and has been doing odd jobs in Delhi to earn a living for the family, his family will suffer immensely if he is to undergo imprisonment for the remaining period out of the 7 years imprisonment imposed on him by the court. He submitted that under the proviso to section 376 subsection 1 IPC, the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 7 years. He submitted that on the facts and circumstances stated above, this court should reduce the sentence in this case imposed on the appellant